number 80 on the calendar. This is the people of the state of New York versus Sharon Lashley. Counsel?
Thank you, Your Honor. May it please the court, Michael Tarbutton for the people. Your Honor, could I reserve 2 minutes for rebuttal?
How many?
2 minutes, Your Honor.
Yes, you may, sir.
Thank you. Your Honor, this court should not expand the illegal sentence exception to the preservation requirement.
Counsel, I'm having difficulty hearing you.
Sure, I'll try to. This court should not expand the illegal sentence exception to the preservation requirement to include the defendant's claim. The defendant argues that the people's omission of tolling allegations from the predicate felony offender statement rendered her sentence as a predicate felony offender invalid. She also argues that she was not required to preserve this claim because her claim falls within this illegal sentence exception to the preservation rule. However, this court in People v. Nieves emphasized that that illegal sentence exception is narrow. It further explained that the illegal sentence exception does not include all sentencing claims. And in People v. Sams, this court set out a two-pronged test for determining whether a claim of sentencing error falls within this illegal sentence exception, and defendant's claim fails both prongs of that test. Under the first prong, Sams explained that to fall within the illegal sentence exception, the defendant's claim actually has to allege that the sentence is substantively illegal. It has to allege that the defendant is actually sentenced improperly, that she's not, in actual fact, a predicate felony offender. It's not good enough to simply allege that there was a defect in the proceedings used to adjudicate her a second felony offender. And that's what defendant here alleges.
Can I back you up a second? Just logically, isn't it the people's burden to establish second felony offender status for sentencing?
Yes, Your Honor.
You have the original record, so you have to establish that, and if you haven't done that...
If we haven't done that, then that means the procedures are inadequate to give the court. That's the defendant, if I'm characterizing it properly, that's the defendant's theory that the legality of the sentence for these purposes...
I'm just thinking of the burden here now.
Sure.
Just the burden. And if you haven't done it, wouldn't it be per se an illegal sentence, if you at least as to that portion of the sentence?
It's an error, Your Honor, but that per se error, but that doesn't excuse the defendant from the obligation to preserve that error. Because simply that something is an error doesn't mean the defendant doesn't have to preserve it. And Sams makes this distinction clear between sentences where there's an error in the proceedings were inadequate, from ones where, as a matter of fact, the defendant's claim was illegal. Sams itself is a claim of an actual illegal sentence case, where in Sams there was this sequentiality.
I think you're right about the defendant's burden to raise the issue. But wouldn't the appellate division have the ability to reach it in the interest of justice?
Yes, Your Honor, it would. And that's what we asked this court to do, is to remand, because it was an error to find that it was preserved as an issue of law, and they could consider it in the interest of justice.
And Counsel, I'm sorry. We could do all of this, but it seems like that's a lot of work for a lot of other courts. Wouldn't a simpler rule just be like, why don't you file a right certificate in the beginning?
No, Your Honor, actually, for a couple of reasons. First, the preservation rule actually is, one of the purposes of it is to prevent unnecessary litigation and to make sure that errors are brought to the attention of the sentencing court and cured on the spot. Had defendant objected, we doubtless would have filed the proper towing allegations because they were in the rap sheet in the court file. We certainly could have done that before. We did that on remand ultimately, not part of this record, but we did ultimately file that. She was adjudicated a second predicate felony offender.
Well, let me stop you there then. Why isn't this moot?
Oh, it's not moot, Your Honors, because for one thing, she was given a different sentence, a lesser sentence. The initial sentence was 3.5 to 7 years. On remand, she was given 2 to 4. So we still have an interest in litigating that.
And is that because of a failure to show the predicate?
No, Your Honor. She was adjudicated a second felony offender at re-sentence, just like she was at the initial sentence. We filed the tolling allegations, which were there was no question she was a predicate. There were 6 years of tolling. And that was, again, evident.
So then you may have to explain to me why the former sentence would prevail over the new sentence.
Oh, because the appellate division's remand order, because it was based on a finding that there was an error as a matter of law, was erroneous. If this court vacates that, then that initial sentence is essentially resurrected, reinstated. The subsequent sentence is a nullity, and then this court would be back to the initial appeal, would have the decision to make of whether to reach the claim in interest of justice, or to not reach the claim, but to consider the defendant's excessive sentence claim.
Well, why was the second sentence lower if it was based on the same predicate?
Essentially, Your Honor, I think it's safe to say it was because of the COVID outbreak. The sentence was adjourned several times. because of the concern about whether COVID was our position was that COVID was not a serious threat, given that it was not very prevalent in the defendant's correctional facility, but the defense counsel took a different position. And
So your view would be if we were to reverse, then the initial sentence, assuming if we have to send it back to the appellate division, it gets through the appellate division again, would be
Right.
reinstated.
Right.
And that other sentencing would be a nullity.
Yes, Your Honor.
Except that I think you said earlier that the appellate division could look at this in the interest of justice.
It could.
Even on the remittal.
It could, which is why, Your Honors, why you should vindicate the preservation rule in this case, because preservation always has the risk that a meritorious claim cannot be raised as an issue of law, but that's why the appellate division has interest of
And
justice
you also
jurisdiction.
think it could be raised on a 440.
Exactly, Your Honors, which distinguishes this case from the vast majority of unpreserved claims where the defendants don't have that option. They have to rely on the interest of justice jurisdiction,
But
which is
then
discretionary.
you're really not sort of meeting one of the fundamental purposes of the preservation requirement, which is some efficiency of some sort, right? I mean, if you're really saying, no, you shouldn't raise it on direct appeal, although you could reach an interest of justice, but if that doesn't happen, you can go by 440, you're multiplying the court proceedings.
Actually, Your Honors, 44020 is a better route to dispose of these claims anyway, because as happened here, on direct appeal, the appellate division can only recognize that there's a procedural error and has to remand. They can't actually address where record's not adequate to determine whether the sentence is actually legal or not. In a 44020, the defendant could have claimed her sentence was illegal if it had any merit. She could have raised that claim and had the sentence corrected in a matter of weeks, as opposed to waiting for over a year for the appellate division to remand it again and start over in a new proceeding to determine whether she was a predicate felony offender or not. So there's still advantages, procedural advantages, so far as expeditiously giving the defendant justice if there was an error, and conserving judicial resources. In a 44020 motion, of course, the parties could develop the record in the first instance. That's the reason a 44020 is there, so that you don't have to go through the cumbersome round of appeal and get back to the sentencing court, develop the record to begin with. So that's another reason why these cases, as a matter of policy, should be channeled into 44020. But as a matter of this court's precedent, this court's test set out in Sam's requires that, because this is not a claim alleging a substantive error, it's only a procedural error, and it's not a claim where the legality of the sentence can be established on the appellate record. So for those reasons, it does fail the Sam's test. And actually, I think the appellate division's remedy they gave is very telling, because the appellate division remanded for further proceedings in the court's words, including the filing by the people of a proper predicate felony statement. So the appellate division recognized that it's quite possible, as ultimately happened, the defendant would be a second felony offender, that her sentence was actually legal to begin with, and also implicitly recognized that it couldn't determine that on the present record. So that showed that this claim falls outside of this test in Sam's and is not part of this very narrow illegal sentence exception. Your Honors, one more issue I wanted to address is that defendant argues that there was a notice problem, that she couldn't...
I'm sorry, counsel, I'm having trouble hearing you.
Sure, sorry. She argues that she couldn't have preserved her claim because she didn't have notice on what tolling allegations she had to dispute. But that simply misunderstands what she had to do to preserve the case. She simply had to point out to the court that the conviction that we allege was more than 10 years old and there are no tolling allegations.
Thank you, counsel.
Thank you, Your Honors.
Counsel?
Good afternoon, Allison Kale on behalf of defendant respondent Ms. Sharon Lashley. This court can dismiss here and should dismiss here as this issue is now moot. Ms. Lashley has been resentenced as a second felony offender.
Counsel, I'm sorry, in that proceeding, though, then it turned out that this was fine. The tolls actually were in place, right?
The prosecution met their burden and alleged the tolling, and that is what happened below with the resentencing, ultimately. But on this record before the court here, there were no such allegations made and no opportunity for anyone to challenge that. So first, this court should dismiss it as moot as to her, and this is not...
But counsel, on the mootness point, aren't the people aggrieved?
The people aren't aggrieved here because Ms. Lashley is a second felony offender. She was ultimately found to have the same...
But on the reversal, there was a sentence that was a reduced sentence from the original sentence, correct?
Correct, she did receive a lower sentence
Okay.
on the reversal.
Thank you.
This is not an expansion of this court's exception to the preservation requirement for illegal sentences. Ms. Lashley's sentence here, there were no allegations about tolling made at all. Under the penal law, this conviction was older than 10 years and could not be used to enhance her sentence.
Yes, but isn't your burden to show the illegality of the sentence from the face of the record? It has to be readily discernible from the face of the record.
It is readily discernible
How
from.
so is that?
Because this predicate was greater than 10 years old, and there is no allegations of any periods of incarceration anywhere in this record. It could have been anywhere else. It's not in the predicate statement. It's not anywhere else in this record either. And the penal law prohibits using a predicate that's over that 10 years when there is no incarceration period. And that's the face of the record that we have here. And it's not a mere procedural violation, it's a violation of the penal law. This predicate could not be used to enhance her sentence, as it was alleged by the prosecution below at the initial sentencing proceeding for Ms. Lashley. And
But to go to your adversary's point then, kind of the flip of what I asked him, why do we want this here now, and especially after there's been a resentencing where this felony actually did comply, it was within the time with the toll, rather than having an obligation to say something then, which presumably what happened just recently would have happened all those years ago? Like, why would we want that rule?
this court has created the exception for illegal sentences for the preservation requirement because society's interest in not having illegal sentences stand is greater than requiring that initial objection.
But this isn't an illegal sentence. We know that it wasn't now. In fact, we really know it wasn't now because you had a resentencing. So why would we do that?
Because it was an illegal sentence when it was given to Ms. Lashley. In Sams and Santiago, there could have been other predicate offenses that applied that made them second felony or persistent felony offenders in the end. They could have gotten the same sentence in the end. In the People v. Fuller case, restitution could have been the same set below. But the problem is, if we countenance these illegal sentences, that's where the issue is.
Your adversary said earlier that your initial burden when you're raising the illegal sentence claim is to show that it's substantively illegal. And I'm sort of having a little trouble with the notion that something could be substantively illegal at one point of time and not at another. That doesn't sound substantive to me. That sounds semantic, almost. So, I'm sorry, can you just sort of help me understand how it was illegal then, but it's not illegal now?
It was illegal then because there were no allegations whatsoever about tolling. The prosecution has the burden to put that forth, and they didn't put it forth. That predicate cannot be used to enhance her sentence on that record.
But that doesn't make it any less legal or any more illegal, I guess.
I mean,
The truth is the truth. I mean, that's a pretty bold statement. The truth can be many things, but you know what I mean.
yes, Your Honor. The problem is on the record before the court, that was an illegal sentence, which was under their own theory substantively illegal as to Ms. Lashley. On that record, you could not enhance her sentence. There are tolling allegations that need to be made. That issue needs to be litigated. That needed to happen below, and it didn't happen here.
Could you distinguish People v. Pellegrino for us?
Sorry, Your Honor, could you refresh?
That's a memorandum decision from this court, which is similar to this, a defendant's argument that there was a failure to comply with CPL 421.
Yes.
And we ruled that it needed to be preserved.
So in those cases, Your Honor, and this applies to Proctor, Oliver as well, and Pellegrino, that's about how the manner of the predicate was determined, and this is about the predicate being used at all in this circumstance, and the predicate under the facts as alleged could not be used at all. It's not a manner determination about how the predicate happened.
I thought Pellegrino was about the failure to include the tolling periods in the predicate felony statement.
Your Honor, I don't believe that was the case specifically in terms of how the record, in terms of how that predicate was actually determined in the end. And that's why it's distinguishable from this case specifically. And to that extent, those cases, Sams and Santiago, put forth a new rule, which would be the one that applies here in this case. And I don't disagree with the prosecution that that's the rule, but the rule that they're putting forward is far too broad. It requires defendants to prove themselves that it's not, that the sentence can never apply to them, and that's not what this court has held, and that's not something that could be established on appeal. So to the extent that Pellegrino, Sams and Santiago put forward the rule that applies here to answer that question. And the notice rule, the our argument about notice, that is the real problem here. The prosecution has the burden to put forward these allegations, and they did not put those forth. And so that's why this illegal sentence exception should apply. And the 44020 is not a vehicle that will solve these problems. In 44020, there's no right to counsel, there's no right to appeal, and also you get to the same result. A plenary resentencing needs to happen here because tolling can actually implicate the sentence that someone gets. How soon someone got out of prison can apply to what kind of sentence the judge is going to get. And those concerns can happen at a plenary resentencing. So that's still going to need to happen, and it's going to be the same effect as litigating this on direct appeal. And there was actually no litigation at all about the tolling periods. The prosecutions conceded from the very beginning that they didn't allege this. It's always only been about preservation. And so the 44020 is not an end-all be-all answer to this issue and to it getting heard. It will result in illegal sentences being insulated from appellate review going forward as well. And to the extent that they're alleging any gamesmanship type arguments here, the prosecutor themselves.
Counsel, I'm sorry to interrupt you. I just have a question based on what you were saying. Would it be possible to get to this issue on direct appeal as an ineffective assistance counsel argument? Or is the record too thin to be able to do that either?
It is a possibility in this case as well. There would be arguments, as you pointed to, that the record doesn't show if there was a strategic reason to not object or not. But yes, and you could reach as ineffective assistance as well, in addition to interest of justice jurisdiction that the appellate division has. If this case were reversed and needs to be remanded to the appellate division for that determination, as well as her excessive sentence claim.
So let's talk about the remand to the appellate division. If this court agreed with you and it's remanded for purposes of the AD to invoke its interest of justice jurisdiction, I assume that what is happening there is that it would invoke its interest of justice jurisdiction to consider a claim that, again, if we hold it's unpreserved, that is unpreserved. But it sounds like you acknowledge that the appellate division will not be able to resolve that issue. It would still have to send it back. Is that correct? So they would end up doing exactly what they did here. Is that correct?
Except for the fact that there is a new judgment that exists as to Ms. Lashley, where the resentencing proceeding has already happened. So it would depend on what this court's order is in terms of what the appellate division considers. But yes, she would need to have a resentencing proceeding, or they could decide it themselves, which the second department did in People v. Tata. They ended up deciding the defendant's sentence themselves.
Okay, but there's where I'm confused. If the record doesn't establish the tolling, how would they do that?
It would need to go back to the
But
appellate.
that's my point. So again, it certainly the appellate division panel could have viewed whether they did this saying it's interest of justice or not, this would have been the same outcome anyway.
Yes. Yes, Your Honor.
Did you make an excessive sentence argument?
Yes, we did as well. That also needs to go
And
before the
they
appellate division.
didn't consider that,
No,
right?
it has not been reached yet.
So they could decline to reach this and then just consider the sentence excessive and impose the same one that was imposed before?
Yes, and Ms. Lashley has
You know, the
been,
one that was just imposed, I'm sorry.
yeah, at this point, Ms. Lashley has been out, released on parole for over a year and a half. The prosecution is seeking to send her back for less than 6 months in prison in the middle of a pandemic.
Thank you, counsel. Counsel, you heard respondents' argument as to why the illegality of the sentence is obvious on the face of the record? You heard.
Sure, I don't-
How do you respond to that?
Well, the procedural error is evident on the face of the record. There are no tolling allegations, and there ought to be. But the illegality of the sentence is not evident on the face of the record, because the illegality of the sentence would require knowing whether there actually is tolling or not. And certainly the rap sheet, which is in the court file, suggests that there is, but that can't be used conclusively. So that suggests that you don't know. And again, the appellate division's remedy showed that. Your Honors, I want to address Judge Rivera's question about ineffective assistance, because I think that illustrates the reason for preservation should be vindicated in this case. If you had a meritorious claim, you might be able to tell on direct appeal whether counsel is ineffective. Here, counsel is definitely not ineffective because counsel negotiated a second felony offender sentence. Everyone knew she was a second felony offender, which is probably why this error happened, because litigators tend to focus on issues that are litigated, not on issues that are agreed to by all the parties. This is why cases, this kind of claim, preservation should be required. so that the defendant can't let an error go into the record that no one cared about because one knew it didn't actually implicate the actual legality of the claim, and then turn around on appeal and litigate it and get the windfall of, frankly, a futile remand, have a do-over that ended up having the same conclusion: the defendant was a second felony offender, which was the initial, of course, the
I
initial.
guess I don't see the benefit to the defendant. I mean, especially because the defendant could have raised this under 440. I don't see why anyone really would do this. I mean, I see it happen here, but I don't understand.
Why, the benefit of actually raising the claim to begin with?
Yeah, if it's meritless.
Right,
Right,
that's true,
well,
or it was.
well,
Which is why preservation would discourage meritless futile claims.
But no, but I'm saying, I think that the fact that it's meritless, I mean, all you get is what? You still, if you're incarcerated, you're still incarcerated, you get a remand, the people put their proof in, and you're where you were. What do you get out of that?
Right, nothing, which is why preservation would prevent those claims being raised as an issue of law.
Well, you'd raise them as 440s.
You could raise them as for 440, but frankly, Your Honors, the defendant is not going to have the motivation to raise a 440.
That's what my point is. I'm not sure why they have any different motivation on a direct appeal. It seems like you get nothing either way.
Right, but direct appeals tend to happen if there's any claim the record could be raised, even if it doesn't benefit the defendant. If I
Did
could...
you used to get
Sure.
something because of the sequencing, which you don't get anymore? Was that one of the reasons they used to want to do this? I mean, was that an incentive before? Because I know we changed some of the sequencing.
Right,
right?
right, where resentencing didn't actually change the sequencing.
Right.
And that wouldn't be, of course, in the defendant's case, because she did commit a crime subsequent to this. That's why her sentence was enhanced afterwards. But that wouldn't affect the case in that. Your Honors, if I could...
Counsel, if I can just ask you, I want to follow up on the question Judge Garcia asked of defense counsel. Could the appellate division avoid the remand for a resentencing by addressing this through excessive sentence?
It could, Your
If
Honor.
it's not clear what the sentence is, I'm just not sure. I'm asking.
Sure, it could. If this court finds that this claim requires preservation, the appellate division erred by reaching it as a matter of law, it would have to remand to the appellate division to determine whether it exercised interest of justice. If it did, that would require remand to the sentencing court for us to re-allege the tolling allegations all over again. If it didn't, it could say that's it, or it could decide that the sentence is excessive and reduce it. So that would be an option the appellate division would have.
Thank you,
Okay.
counsel.
Thank you, Your Honor.